everyone, my name's Julia Palermo with Palermo and Associates located in New York, and I'm here today to answer your pressing litigation questions. But first, please don't forget to like, subscribe, share, and follow me on Instagram and Twitter. All the links are in the description box below, along with all my other information. Hi, so today I'm going to talk to you guys a little bit about the civil litigation process. Understand that there may be some variations to this process, and this doesn't apply to criminal cases, which has a completely different process in of itself. So there are a couple of variations, but usually a civil litigation is started when one party files with the court a summons and complaint or a summons with notice. This is what lets everyone know that they have a complaint, and they have to list within this complaint all of the elements of their complaint or what they're claiming, be it like a foreclosure or a personal injury. They have to list what it is that they think you did wrong, and your name, your address, and a few other necessary information in the complaint. After this is filed, then they have to serve it on you. They have to get a process server who has to go to your house and either serve it. It depends on the case. So like with divorces in New York, they have to be personally served. And some of the other cases, civil cases in New York, if they try to personally serve you and you're not there, they can do what's called nail and mail. So they nail or they leave the complaint with someone of suitable age, or they put on your door, and then they go back and they mail you a copy. After you get the complaint, it's then the person who receives the complaint then has to file and answer, because you don't want to just sit there and let this complaint wait. You have to file and let the other side know, hey, we don't agree with anything or some of the things that you put in your complaint, and we want to dispute them. So that's usually what's done, and then that gets filed with the court as well. After that, we have what's called the discovery phase. And then usually there's a discovery phase. Usually what happens here is that the judge will set up what's called a preliminary conference or some type of conference, which they'll have everyone come in, and then they'll set dates for when discovery has to be served. Discovery is when each side has to send to the other side the information or evidence that they have that they believe proves their case. Obviously, this is going to vary depending on the type of case that you have and what what's being sued, what's being disputed. Are there photographs, documents? There's usually a bill of particulars that's included in this as well. So there's all different things that come into play when dealing with discovery. So you do that, and then after the discovery stage, there may be motions. Now, sometimes there are motions before the discovery phase, and I know in foreclosures, the bank will usually file what's called a summary judgment motion, and this is saying that there's no facts to dispute, that based on the facts that exist, that they are entitled to a judgment by law. This can happen before the discovery phase. It can also happen after the discovery phase. This usually happens though before a trial, because once a trial happens, it's a little harder to file motions like this. So you have your complaint, your answer, and then you have the discovery phase. After these are done and complete, and you've exchanged discovery information, at the tail end of the discovery phase, we'll have depositions. In New York, we call them EBTs, but everywhere else, my understanding, calls them depositions, which is where you will ask questions of the other party or third parties or anyone involved in your case, and you sit them down and you ask them with a court reporter in front of them. And then once that's done and that's all set up and that's all finished, you can either settle your case, which your attorneys, I'm sure, will be trying to do actually from the second they either put out the complaint and receive their answer, or they send out the answer. They're probably going to be trying to settle your case from the start until the trial. So after discovery is done is actually when the trial will start. If you haven't been able to settle your case, you have a trial. You either have a trial in front of the judge or in front of a jury. That's something that it's it's really something that your attorney is going to decide, and it's going to depend on the type of case you have. Not every case is going to have a jury. There's going to be quite a few cases that actually have just a judge who's going to be overseeing your trial and making a decision. So it really depends on your attorney's strategy and on what type of case you have. After that, after the trial, then there's a decision. If, let's say, you get a decision from this trial and you're not happy, you're like, no way, this judge messed up, or this jury was completely wrong, like I don't know how they even got this. You actually can appeal the trial. Some areas I know isn't like New York. In New York, in state court, you can appeal at every single process. So if you get like a motion and it gets denied, you can appeal the denial. But again, at the end of the trial, once everything's finished, you can appeal and be like, go to the appellate court and be like, hey, I don't agree. I think that the judge made a mistake because, you know, these were the facts. And you can only do what's been presented, understand as well. You can't appeal and bring up new facts and new law. That's not going to happen. But if you appeal and you're like, hey, based on the facts that were presented, I made these objections, or based on this law, the judge made a mistake. There was an error. This is the error that they made, and this is why I should win, or why the determination should be overturned and gone sent back to trial. This either is done by briefs only, or sometimes you can do oral arguments. It really depends on your case again as well. But this is kind of like your last chance. So if they make a decision and they're like, yeah, actually we agree, there was a major error, the judge made a major error, this shouldn't have happened this way, we're gonna send it back and the judge has to redo everything and you get to do a retrial. But if you go there and they're like, nah, we agreed, we think the judge did the right thing, we don't think there was an error, your case pretty much ends there in that respects. Now, everyone thinks that the trial is actually the end, that you get a decision and it's over. I wish it was so, but no. I mean, you got the trial, right? You went to trial, you got this award, they said, okay, you're entitled to X amount. Now what happens? You gotta try and get X amount. Sometimes, and this happens more often than it should, people don't want to pay after they lost. So you have to try and get your payment. So there's a whole nother process actually after the trial where you try to enforce the judgment. You can garnish wages. You can ask the sheriff to do that. You can ask like the employer to do that. There's like a whole bunch of ways that you're gonna have your attorney, or your attorney is going to try to enforce your judgment. So it's not as straightforward sometimes as you would like it. I know it'd be really cool to just win the trial and everything's finished, but quite often there's also a whole separate process that comes after you've received your either, you know, denial or your win. So that's just kind of like a really, I know this is really quick, actually, super quick overview of like the process.